Sir, are you here?
Yes, yes. Should we start?
Your voice is very low.
Just a minute.
Okay. Good morning, everyone. I welcome you all to the workshop on the topic. Today we have with us Amit Gupta sir as faculty for taking session on the topic Interplay of IBC with SEBI Act and SARFAESI Act. Let me briefly introduce Amit Gupta sir. Sir is member of ICSI and IP. He is passionately engaged in practice of profession for more than 20 years in corporate and allied laws and providing out-of-box solution on complex legal and science and law graduate and diploma holder in banking and financial analyst of India. He is also chairman of corporate law committee of NIRC and
Anjali, if I'm audible?
Sir, now you are audible, but the sound is breaking.
Yes, sir, audible, sir.
So, good morning, friends. Uh, is it better now?
Yes.
All
It is.
right. So let me just share the screen as well. So, good morning, friends. The discussion that we are going to make today is with regard to the interplay of Insolvency and Bankruptcy Code with the Securities and Exchange Board of India Act and regulations made thereunder and the SARFAESI law. It's been almost more than 8 odd years, ninth year will start from the commencement of Insolvency and Bankruptcy Code. And in the last more than 8 years period, the law has evolved very well. And we have seen the interplay of Insolvency and Bankruptcy Code with various other legislations. So the topic that we are confined to today's discussion is more on a interplay between Insolvency and Bankruptcy Code vis-a-vis SEBI and other allied regulations, and also the SARFAESI. So what we are going to do is we need to just understand the framework. What is the board decision-making process, how the corporate functions, suspension of the powers of the board of directors, corporate actions which are done pursuant to the resolution plan, compliances, filing of forms, and then what is the framework of compliances under the securities law? What are the relaxations given under the SEBI LODR regulations? What are the relaxations provided under SEBI ICDR and relaxations provided under SEBI SAST regulation 2011? And also we will go through the provisions of relaxations given under SEBI delisting regulation 2021. And last but not the least, the relaxations under the Securities Contract Regulation Act and Regulation Rules. Then there are certain issues which require the attention, and also we will see the interplay between IBC and SARFAESI. So let us begin our discussion for today. If I talk about a company, the corporate functioning, the company being a separate legal entity cannot act on its own. It needs the people to act upon. So the owner of the company, that is shareholder, appoints the body called as board of director to discharge all its functions. Section 179 of the Companies Act gives a power to the board of director to do all such act and deed as the company is capable of doing, except those things for which the law specifically mandates that these things will require the prior approval of shareholder, or article of association mandates that this is subject to the approval of shareholder, or shareholders by their own resolution decides the restriction on the power of the board. Barring these three conditions, rest all powers can be exercised by the board of directors. Now, board of director decision making is through various mode. Either it can be through a meeting of board of director, or through meeting conducted through the virtual platform, or by way of a circular resolution. Majority of the items which can be conducted by the board of directors through physical meeting can be approved by way of a virtual meeting also. Nowadays, since COVID time 2020, the relaxation came, and now whatever can be done by the board physically can be done virtually also. However, the distinction between the items which can be tabled through circular resolution, and the items which can be done through the physical meeting or virtual meeting, there always remains a gap. And that gap is rightly so, because intention of a lawmaker is very clear, that they want to come to a forum either virtually or physically to deliberate on those all items which require a mutual deliberation, which requires a matter of significant importance, like approval of the financial statement, right? Approval of a board of directors report, right? So all these items which are intended to have a exchange of thoughts in between, where resolution is dependent on discussion more, those items are considered for the purpose of board of directors physical meeting. Otherwise, rest all items can be taken up by way of a circular resolution also. Then there are certain committees, then there are certain powers of the board. Powers of the board we have understood flows from section 179. Section 180, 181, 182, 183, 184, 185, 186, or even 188 is all about the restrictions on the power of the board. So I will not go into deep into each and every power, but yes, there are powers which are captured in section 179, which are not absolute. There are restrictions on the power of the board. Section 180 to 188 deals with those restrictions on the power of the board. Now, question arises how the board decision making process is done. As we discussed, that board is a separate company, is a separate legal entity and acts through its board of director. 179 empowers the board to exercise all such power and to do all such act as the company is authorized. Now, board decision making can be through virtual meeting or through a physical meeting or by way of a circular resolution. Board may exercise power on its own, or it may delegate the power to any person or to any committee. Law also mandates for constitution of certain mandatory committees for discharge of its overall functions. As you know, as and when the corporate insolvency resolution process triggers, the powers of the board of directors are suspended. In terms of the provisions of section 17 of the Insolvency and Bankruptcy Code, the powers of the board are vested with the interim resolution professional, who is supposed to discharge all these functions. Now, in this regard, it is important to understand what section 17 of the IB code talks about. Section 17 says the management of affairs of corporate debtor by interim resolution professional. It says from the date of appointment of IRP, the management of affairs of the corporate debtor shall vest in the IRP. The powers of the board of director or the partners of the corporate debtor shall stand suspended. Mark the word, it is the power of the board of director which is suspended, not the power of the individual director. It is not the power of a board that is, it is not the power of the director that is suspended. It is the power of the board that is suspended. Board is a collective body in comparison to the individual director. And it also says that the power shall be exercised by the IRP. All officers, managers of the corporate debtor are required to report to the IRP and provide access to such document and record of the corporate debtor as may be required by the IRP. Financial institutions who maintain the account of the corporate debtor will act on the instructions of the interim resolution professional in relation to such accounts. So whatever bank accounts were being operated earlier by the director, manager, or the other people, they will act on the instructions of IRP and will furnish all informations relating to corporate debtor available with them to the IRP. It also says that IRP shall be vested with the management of corporate debtor, shall act and execute in the name and on behalf of the corporate debtor all deeds, receipts, and the documents, if any. Will also take such action in the manner and subject to such restriction as may be specified by the board. They will have such authority to access the electronic records of the corporate debtor from the information utility having financial information of the corporate debtor. The IRP will have the authority to access the books of accounts, records, and other relevant document of the corporate debtor available with the government authority, statutory auditor, accountant, and such other person as may be specified. He shall also be responsible for complying with the requirement under any law for the time being in force on behalf of the corporate debtor. So this is a plain vanilla section 17, which very clearly talks about the position as and when the corporate debtor comes into corporate insolvency resolution process. Now, there are certain issues which we need to deliberate to have a clarity in mind so that we can clearly visualize what is the interplay between the insolvency and bankruptcy vis-a-vis SEBI law, vis-a-vis SARFAESI law. If suspension is of board or suspension of powers, board versus power. So clearly answer is it is only power of the board is suspended. Board as such is not suspended. The board remains there, but power does not remain there. Power, if exercised by the board of director, will be subject to the approval of the interim resolution professional. It is not that board cannot function, but the functioning of board of director is under the eclipse of the powers of the interim resolution professional. Whatever he does will be only under the shadow of powers of the interim resolution professional. Second question that arises, if suspension is of powers of the board or powers of the individual directors as well. So as we discussed previously, it is only the powers of the board as such are suspended. The powers of our individual directors are not suspended per se. Now, what could be the power? Power could be administration. Say there exists a managing director. So situation may be that CIRP has commenced because it is not the suspension of an individual director or the board of director, suspension of a power alone. So the directors, the managing director can continue to function, but under the control and guidance of a IRP. They will draw the power not from the board of director, but they will draw the power from the IRP. So IRP will replace the position of a board of directors, and from the powers of the IRP, individual directors who may be managing director, who may be director finance, who may be whole-time director, who may be director HR, who may be director marketing, and so on, can continue to function. The only thing is that the reporting hierarchy of the managing director and the other directors will now become the upline to the interim resolution professional. Third question that arises: if a director, managing director, officers, and others can continue to exercise the powers as delegated to them by the board prior to appointment of IRP. This is very pertinent question. There was a managing director who was operating the plant, running the unit as per the delegation of power made by the board of director previously. Automatically, if a power was delegated, the power will remain with the managing director unless IRP takes a decision that all powers provided by the board of director by way of a previous delegation of power are suspended. Unless suspended, these individual directors' powers will remain there, and he will be capable to continue to discharge the functions what he's supposed to. It is only when the IRP says no, nothing doing from the date of commencement of CIRP, all powers delegated by the board of directors are suspended. They will vest in the IRP, and IRP will now re-delegate the powers as per his own requirement. And in that delegation, if a managing director is being asked to continue the functions of running the operations of a unit, then he will continue, or he will discharge the functions as the IRP directs to him. But if nothing has been decided, then by virtue of previous delegation, he may continue to discharge the functions what he was previously discharging. There is no difficulty with regard to the same. So generally, the disruption happens only at a level of a board. Individual directors, minor here and there powers, maybe like bank account operation and other things may be there. Otherwise, barring the powers of the board, everything continue to be in the same fashion. It is only that supervision now is of a interim resolution professional instead of a board of directors. If IRP, RP has all the powers of the board or powers in respect of items covered in section 17.2. This is very important question. Let us recapitulate what was section 17.2. 17.2 was talking about management of the corporate debtor to act and execute in the name and on behalf of corporate debtor, deeds, receipt, and other documents, to take such action in such manner subject to restrictions as may be specified by the board, shall have authority to access the electronic record of the corporate debtor, shall have authority to access the books of accounts, records, and other relevant documents. Now, question arises whether he has powers limited to section 17.2 alone, or he has a power, all the powers which the board of directors can exercise. So both extremes are not correct. If I say that he has a powers which are limited to section 17.2 alone, may not be correct, because in due discharge of his functions, he may have to exercise the other powers of the board also. And on the other extreme, if I say whatever the board of director was capable of exercising, he will be capable to exercise all such power, that may also not be correct, because the eclipse situation, there are certain counter checks and balances, because unit is not functional. It is only the interregnum period for which this arrangement has been done. So whatever company can do may not be possible to be done by the IRP, or may be possible to be done by IRP, but only with the checks and balances of the committee of creditors. There are certain powers which are exercisable by the IRP only with the approval or consent of the committee of creditors. So absolute extreme is not there in respect of full powers as far as the power of the interim resolution professional is concerned. Another point is very relevant. If a suspension of powers of the board absolves the directors from its duties as well, duties are not discharged. It is only power of a collective power of the board of directors which is discharged. So duties which are captured in section 166 as well as the common law duty will continue to be the duties of the directors, and they will continue to do a due discharge. So duty to protect and act in the best interest of the company, its employee and stakeholder. Protection of environment, flora and fauna is one of the prime important duty to prevent the situation of a conflict of interest. And likewise, so he really cannot consider that because the power of the board is suspended, so he has no role to play in the company and he can run away from the show. That simpliciter is not possible, because it is simply suspension of the power of the board, not the individual director. So duties of an individual director continue to be there even after the commencement of CIRP. Next question arises: if a IRP, RP competent to take decision on all matters for which the board is empowered under the Companies Act 2013. Again, this is the same question in a different frame. These powers are also not absolute, because section 179 per se, whatever powers are available to the company are available to the board of directors. Now, when board powers are suspended and IRP is appointed in the interregnum period, he has to work until the resolution plan is approved by the board and the company is discharged from the NCLT. So he has to function in accordance with the purpose and duties specified in the Insolvency and Bankruptcy Code. Whatever is considered necessary for keeping the company as a going concern, for if the company is a going concern, whatever is considered necessary for facilitating the approval of a resolution plan. So in that context, whatever is required and whatever is required for the purpose of compliance with the applicable provisions of law. So whatever for that purpose is a requirement, and specifically section 17(2), whatever talks about are those specific powers which the IRP will be exercising. If IRP, RP competent to take decision on all matter where the power of the board is subject to approval of a regulator under the Companies Act, if approval of regulator required, like company conversion of company from private limited to public limited or public limited to private limited, is subject to the approval of Ministry of Corporate Affairs. Can IRP say, because I am under CIRP, I did not follow anything and everything, whatever is mentioned in the law, I am vested with full powers? Answer is no. He is not vested with full powers. Whatever as per requirement of law is required to be subject to approval of the regulator will always remain with the subject of approval of the regulator, or whatever powers are subject to approval of the shareholders, those powers will also remain as a subject matter subject to the approval of the shareholders, like approval of the financial statement, adoption of the financial statement, appointment of a statutory auditor. Whatever Companies Act has provided that these powers shall be exercised by the board of directors subject to necessary approval from the shareholders. So these powers will be subject to approval of the shareholders. Now question arises, if the board has any residual power. Why this question is arising? Because this question has a basis from the previous regime of liquidation. When a liquidator is appointed, the board and the employees are suspended and their powers are suspended. But there is a catch, that suspension is having a rider that it will have a residual power vested with the board of directors if XYZ situation arises. But that is a matter of liquidation. Here the company is in resolution process. Here the board of directors will in no situation have that residual power. Many judgments of NCLT, NCLAT, Supreme Court have time and again affirmed that even if a appeal is required to be filed against the order of NCLT for commencement of CIRP, the process needs to be initiated on behalf of the affected party. It may be a promoter, it may be a director. In their individual capacity, the representation in appeal on behalf of the corporate debtor will not be possible. So the residual power condition as far as insolvency and bankruptcy code is concerned, that does not remain there. If RP shall become officer in default under the provisions of the Companies Act 2013 and be held liable for non-compliances, if any, in the management of affairs of the corporate debtor? Answer is no. The insolvency resolution professional, when discharging the duties as a IRP or RP, is acting as an officer of the court. He is not officer of a corporate debtor. So technically speaking, he does not fall in the definition of an officer in default under 2 clause 59 of the Companies Act. But yes, IBBI has issued circulars time and again. Even section 17(2) also mandates the IRP to ensure the compliance of all applicable laws. So he will be under the obligation to make necessary compliances, though he will never be classified as an officer in default under the provisions of the Insolvency and Bankruptcy Code. Yes, someone was having some query, please. Yeah, you can unmute and ask. If there was any question on this point.
No, please proceed.
All right. Then not only.
Sir, excuse me.
Yes,
Excuse me.
Shekhar ji?
Yes, sir. Actually, I want one doubt to be clarified. Once the board of directors itself is suspended, then where is the power we will get it there? Because you explained that the board directors' power is not suspended, but only the board is suspended. So once the board
Correct.
itself is abolished or suspended, and where is the question of the directors' powers?
I will explain.
Hmm.
See, what is the difference between the board and the director?
Hmm.
The difference between the board and the directors is that directors, when acting in a collective manner, are called the board of directors in terms of the provisions of the Companies Act. And they are vested. No individual director is vested with any power. It is all the powers what are delegated by the board of directors to the individual director. So even if I am a managing director, I will draw all the powers only and only from the board of directors. Section 179 is a mother provision, and we need to understand. Shekharji, you can mute your mic. Let me explain, and then you can unmute if you have still any question. So the managing director, whole-time director, or other individual directors will have no powers with regard to any of the matters individually. It is only when the board of directors collectively decides that we are delegating the day-to-day operations to the managing director. So he will be vested with the powers with regard to the managing the affairs of the company. When I delegate the finance function to the finance director, those powers will be vested. Now, question arises when the CIRP commences, whether those powers will continue to be whatever has been delegated automatically by the board of directors to the managing director, director finance, director operation, director technical, and so on, and to the employees even, to the general manager, to the manager, to the accountant, right? Whether all the powers are suspended? No. The suspension is only of a supervisory body, that is the board of directors, who is a policy making body. What will happen to the powers of a down below? The down below powers are subject to decisions of the IRP. If IRP says no, whatever previous powers have been delegated by the board of directors, they also stand suspended until by further order. I will decide what are the new functions and what are the new delegations. So if he chooses to define a new hierarchy of the delegated functions, basis that the functions will be undertaken by the respective person. Otherwise, whatever delegation has been made, those functions will continue to operate. They will continue to be effective. That's where the point that I'm trying to make, that it is only suspension of the power of the board. By default, the power of the individual director, if already vested with by virtue of exercise of the power of the board in the past, will continue to be exercised by default. However, you may choose that nothing doing from the date of commencement of CIRP, and from the date the IRP is vested with the power of the management, I suspend all previous delegation of power. Now, this will be the new organization hierarchy, and this will be the new power delegation system. If that is so, then then I am giving him the power. The IRP is vesting him with the power to operate the company. Director finance to discharge the finance function. It is not that the insolvency and bankruptcy code is meant to disown the power of the individual director. It is only that IRP comes as a super decision maker in replacement to the board of directors' power, to decide as to what is in the best interest of the company, because this is not the routine business function. This is now coming under the eclipse of CIRP, and it needs to be a creditor-driven insolvency, where creditor in command will decide how the operations are to be functioning, right? Because it is not a debtor-led regime, which was the enjoyment of the corporate debtor until the unit went into CIRP. Once you slips into the CIRP, then you have no choice, but it will be the creditor who will be deciding as to how the company will be functioning. So the point that I am trying to make, it is suspension of the power of the board. It is not the suspension of the power of an individual director. In that context only, I was trying to explain that. Shekharji, if that clarifies this particular point, can we move?
Yes, sir. Yes, sir. Thank you. Thank you.
Then protection against the action taken in good faith by the interim resolution professional or the resolution professional. I think there are n number of matters which have gone to right up to the Supreme Court, where I know the pain point of our ERP, RP. I am also functioning in many of the cases, and we have seen and we have witnessed the bad incidences which had taken place with the IRP, RP. But at the same time, we must also appreciate that courts and tribunals and appellate tribunals have time and again upheld the sanctity of the officer appointed by the court, that is IRP, RP. And whatever is done by him in a good faith will always remain protected, will be protected by the court also, will be protected by the NCLT and the appellate tribunal also. Protection against the initiation of the civil criminal proceeding against the IRP, RP. There is a legal provision also, as well as there is a court ruling also in respect of many of the matters where the court has held that there is a process that we need to follow with regard to initiation of a civil criminal proceeding against the IRP, RP. I agree that there are many matters where the mishandling, manhandling, and the other allegations have been leveled against the IRP, RP, and they have been punished and they have been penalized, and the penal action have been initiated. But yes, the intention of the law is very clear that they want to provide enough protection to the people. I think this is the explanation what we have already discussed. Will not cover each and every. We have already discussed these. Now, if you see what is the officer in default, 2 clause 60 of the Companies Act defines the officer in default. The resolution professional is agent of the adjudicating authority and not of the company or any of its stakeholder. The RP is a specialized professional and not the employee of the corporate debtor or a businessman. If you see the definition of 2 clause 60 also, it includes a whole-time director, KMP, and when there is no KMP director who has consented to act on or all directors, other persons charged with the responsibility, deeming directors on whose directions the board is accustomed to act, and every director who is aware of such contravention by virtue of receipt of minutes or participation in the board discussion and board agenda papers. registrar and transfer agent, and the merchant banker. Now, let us understand certain principles with regard to the processes that are being conducted during the CIRP. What will be the position with regard to the meetings of board of directors? Insolvency and bankruptcy code nowhere provides exemption to the meetings of the board of directors. If you go to SEBI law, SEBI LODR dealing with the requirement of holding the meeting of board of director or committees thereof is made inapplicable during the CIRP period. We have crossed more than 8 years, and this issue has been flagged before the top authorities, and everybody is aware. Either the decision should be made by the concerned authority that no meeting is required to be held as the board is suspended, or we continue to take a view that yes, power of the board is under eclipse of interim resolution professional or a resolution professional. So whatever you decide will require further vetting by the IRP. But I can continue the board functioning, the decision making by the board of directors. And that is the dilemma which leads to many of the companies who continue to hold the meeting of the board of directors, where IRP, RP is also present or is present in a meeting separately. Whatever decisions are taken are under the supervision and the umbrella approval of the IRP. So there are practices. So I am of the view, unless specifically exempted, why government so far has not considered this request of the IRP and RP for the purpose of bringing a clarity whether they want, because SEBI law has exempted. Either SEBI law would not have exempted, I could have understood, because SEBI law is giving the exemption. Companies Act is not providing any exemption with regard to this. And moreover, if you talk about certain returns, there also we are left with no choice but to put the details of the COC meeting in the MGT 7 form that we are filling with regard to the date of the board meeting, because that's a mandatory field. And ultimately, we have to fill some details therefore. And many of the IRPs during their period, when they fill and file the MGT 7, they put a clarification that these dates are the dates of a committee of creditors meeting, not the date of a meeting of a board of directors. But there are companies who are holding meetings also on the quarterly basis or on the intermittent basis, and they are chaired by the interim resolution professional, which are for the purpose of discharge of functions from day-to-day basis. And this practice is more prevalent in those cases where your board of directors still continues to be there and is cooperating to the extent IRP desires the support and the unit is going concern, right? There, IRP alone may not be sufficient for the purpose of running the unit. It's very tough because if existing management and the board of directors does not cooperate, then it becomes very difficult. So our resolution professional takes over the management of corporate debtor on as is where is basis, and just that the management comes under the power of the RP conferred on him under the law. The officers continue functioning as they used That is what my opening sentence was. The meetings of the board and that of a committee of the board will continue to be conducted in accordance with the applicable law. The decision taken by the board shall, of course, be subject to the concurrence of the resolution professional. If you see the provisions of section 134(1), which says the financial statement, including consolidated financial statement, if any, shall be approved by the board of directors before they are signed on behalf of the board by the chairperson of the company, where he is so authorized by the board, or by two directors, out of which one shall be managing director, if any, and the chief executive officer, CFO, and the company secretary of the company wherever appointed. Or in case of a one-person company, only by one director for submission to the auditor for his report thereon. So 134(1) also does not talks about any exemption for a company in the CIRP. So that means the intention of law seems to be that you are left with no choice but to get the signing of the financial statement in the manner spelled out in section 134(1). But on the other hand, suppose there is a case where the ex-management or the promoter is running away, is not available, what you will do? Can IRP on its own prepare the financial statement and sign and submit it for the purpose of adoption to the shareholder? Answer is yes, it is possible, and many of the IRP, RP are doing so because they cannot keep the compliances. 17(2) para last specifically talks about, and there is a circular of IBBI of April 2017, which very clearly says that IRP is duty bound to discharge its duties and keep the compliances of the company in good health. So I have no option but to do necessary compliances. Maybe if managing director is not cooperating, IRP can put his own signature, and these balance sheets will also be submitted to the shareholders for the purpose of their adoption. Now I can understand where the challenge could be that on that particular date, the shareholders of the company may be 100% promoter only. How you will adapt these financial statements? You may have no option but to file the application before the NCLT, and NCLT may come out with some solution. In one of our matter where the entity was a listed entity and the promoters were holding majority of the shares, that was as high as 75%, and public participation was not there. So they were not approving the financial statement, and we were not able to move forward. Then we made an application and we requested NCLT that during this eclipse period, kindly permit us to exclude the votes of the promoter, ex-management, for the purpose of considering the approval, and necessary directions were given and we could move forward. But matter of the fact remains, 134(1) stands as it is in the books of the Companies Act without any amendment and modification. That compels us to continue to make endeavor to make necessary compliances in this particular frame. Section 34(6), the board report and any annexure thereto under subsection 3 shall be signed by the chairperson of the company if he is authorized by the board. This is about the board report. So likewise, as there is no exemption with regard to the financial statement, there is no exemption with regard to the board report also. 134(3)(d) also talks about that the board report shall inter alia disclose number of meetings during the year. This also is not exempted by any chance so far. Then annual return, as I was talking under section 92, in Form MGT7 mandates the disclosure of date of board meeting held during the year along with the presence of directors. This clause again is not exempted or is not modified in the Insolvency and Bankruptcy Code. So we have left with no option but to consider that the board meetings can be held as far as practicable, where the board of directors continue to support the insolvency resolution process and they continue to come and attend the meeting. Of course, the meeting will be supervised and chaired by the interim resolution professional or the resolution professional, and basis that only the decisions will be implemented. Now, corporate actions in pursuance of the resolution plan. This is very important that how the corporate actions are to be considered and how these corporate actions are considered for approval. So, say the corporate action is regarding the issue allotment of shares, changes in director, key managerial personnel, reduction in share capital, buyback. So whatever is a part of the resolution plan, whether it is increase in share capital, reduction of capital, issue of fresh shares, changes in director, changes in KMP, buyback, everything will be covered under the resolution plan. And to the extent it is covered in the resolution plan, no further action is required by the corporate debtor in respect of any of these matters. You will see the SEBI exemptions also. So if you are unlisted entity, you need not go to shareholders for taking their approval. Maybe you are doing a preferential allotment, maybe you are doing a buyback, maybe you are doing an increase in capital, or maybe you are doing a changes in director. Normally you require the approval of shareholder, but in case of a CIRP implemented resolution plan, you need not take any approval. And if you are implementing something which you missed out in the resolution plan and now it is afterthought that we want to do such changes, suppose you missed out to nominate the directors in the resolution plan, or the resolution plan does not talk about who will be the new management, you have no option but to convene the appropriate meeting as per the process laid down in the Companies Act to follow. And that's why it is very important that in many of the matters we have seen that companies resolution plan have failed to list out these items what we are talking about, and that creates a very embarrassing situation for us when we come for implementation. So if the reduction of capital was envisaged, the resolution plan only says that the resolution applicant shall infuse X amount of money and company as a per part of the resolution plan will issue the shares. There is not a single mention about the cancellation or reduction of existing capital. Now, what is the fate? Fate is inadvertently you have missed out the reduction of capital as a part of the resolution plan. How you will reduce your capital? That is a $1 million question which will come when you will come to implementation. Now, whatever is not captured in the resolution plan will go for the normal process. That means you will have to file further application before the NCLT, maybe in continuation to your application for approval of the resolution plan. In continuation, you will say, "Milord, this was missed out. You kindly allow us to do that." That's the only option. Otherwise, you will have to follow the reduction of capital process. Similarly, for a smaller item, maybe buyback or maybe for other structuring, if you have missed out, you have no option but to go for the same. So to avoid these kind of small technical issues and avoid the pain that can come later, it is best advised that we prepare the resolution plan with utmost care. Whether you have a responsibility tomorrow to implement, or you may not have a responsibility to implement, some other professionals will have the responsibility, but at least ease out the thing as much as you can. Otherwise, it will be a pain for the IRP, RP, or the other consultant who will be trying to implement the resolution plan, which is already approved by the National Company Law Tribunal. Related party transactions, borrowing power, investment. These items specifically needs to be taken care while approval of a resolution plan. If you miss out, then again, you may not have a time to go to shareholder to take the approval of shareholders, because at the time when you will be implementing the resolution plan, the shareholders may be the previous shareholder only. How you will cycle it out? I can say with my experience that invariably in many of the resolution plan which comes for implementation, these are the problems, that everything is not well thought of in the resolution plan, and it is just that on a surface of it, we have broadly approved the numbers, that this is the payment, this is the repayment, this is the deferred payment that we are doing. Rest all the operational part, how it will be achieved, from where the fund will come, is completely silent about. It's not talking about, right? That's where the problem arises. So we need to ensure that this part is also taken care of in the resolution plan. If a resolution plan does not provide for vacation of a statutory auditor on the closing date, one of the very recent example, we were implementing a resolution plan, and statutory auditor position was filled about a year back when the company was in CIRP in the middle of a resolution plan approval. Now, resolution plan nowhere says that the statutory auditor will have to vacate the office and a new statutory auditor shall be appointed. Now, consequence is that if you want to, the new resolution applicant requested the company, requested the auditor to submit his resignation. He denied to submit the resignation, saying that there was not such an understanding. I will continue for remaining 4-year period. Now, difficulty is that had that been a part of a resolution plan, that the existing statutory auditor will resign and the new statutory auditor shall be appointed by the corporate debtor or the resolution applicant, then this problem could have been solved. Otherwise, now we are left with no option. Either I go to NCLT to get the approval for modified plan, or I go to regional director to follow the process under the Companies Act for removal of a director, for removal of a statutory auditor. So these are the areas where a lot of planning is required in respect of these kind of situations. And on the other hand, there is also a live situation where the resolution plan provided for automatic vacation on coming into effect of a resolution plan. However, it does not talk about the appointment of a new auditor. Now, my entity got order, let us say on today, that is on 20th of September 2020, 5. And my entity is a listed entity. I have to submit the quarterly financial statements also. For September quarter, I will be in the obligation to submit my quarterly financial statement by 14th of November 2025. I have no auditor in place. Now I want to submit the financial statement, but during this short period of time, I could not appoint. I had no option but to delay the filing of financial result with the stock exchange. So the point, again, I am repeating, is that we need to be very careful with regard to the wordings what I am using for the purpose of resolution plan, how I am going to implement end to end the resolution plan. That is the crux. Next comes the compliances. The January 3, 2018 circular mandates to comply all applicable laws unless the provision is specifically exempted by competent authority or becomes inapplicable by operation of law for the corporate person. IRP, RP liquidator for a corporate person shall exercise all reasonable care and due diligence and take necessary steps to ensure that the corporate person undergoing any person process under the code complies with the applicable law. If corporate person suffer any loss, including penalty, if any, on account of non-compliance of any provision of the applicable law, such loss shall not form part of the insolvency resolution process cost or the liquidation process cost under the code. Insolvency professional will be responsible for all such non-compliance for the provision of the applicable law if it is on account of his conduct. This circular gives quite a lot clarity as to what IRP, RP is supposed to do, how much care he has to take. But I know howsoever best care he takes, there are certain situations which are not in his control, but they are in control of the ecosystem. So, but still the endeavor has to be made so that he can make the best necessary possible compliances. Filing of forms, I think this has been quite a pain from time to time, thanks to MCA V3 system, which has reasonably to the large extent resolved all the problem, primarily with regard to filing of INC 28 driven problem, where you keep on filing INC 28, but system status continue to be remained as active, whereas it should have been under CIRP or under CIRP to active, but it does not change later on. So you are supposed to file INC 28 at the time of order for admission of CIRP. Similarly, at the time of discharge of the corporate debtor from the CIRP process, or when the liquidation is triggered, or when the company is dissolved. Right. So all these 4 stages, the order of NCLT is filed in form NC 28. Now, because the process is integrated, it is done seamlessly. The moment you file and the form is approved, automatically the status of corporate debtor gets updated on the MCA portal and the status is shown to the correct position, whether it is active or in CIRP or whatever it is. As far as filing of other forms are concerned, I think the major one requires the filing of annual filing form AOC 4 MGT 7. So ministry has given a relaxation. Of course, you have an option to file AOC 4 and MGT 7 with the normal filing fees also, if there are director, company secretary, KMP available for the purpose of signing of these forms. Otherwise, you can file the form GNL2 also for the purpose of making necessary compliances, and you will not be subjected to any additional fees if you have filed these forms. I think that's it as far as this first part of discussion is concerned. There are a couple of questions which we will take up just immediately after. Just give me 2 minutes. I have one phone call to attend. I'll just join back. Just 2 minutes. Yeah. So there are few questions with regard to the CIRP process and what we were talking about interplay with other laws. Can a director resign during the CIRP period? If you technically ask uh, the position with regard to this, this is a position under Companies Act as well as Insolvency and Bankruptcy Code, the action of resignation is not in the hand of a IRP. What IRP is restricted that he cannot make any change in the management of the corporate debtor without prior approval of the committee of creditor. 28(3) further requires the approval of vote by 66% voting share, right? But as far as resignation of a director is concerned, it is a relinquishment of office by the director. This is a unilateral act. Unless article mandate, it is not contingent upon acceptance by the company. The moment he resigns, he ceases to be the director. So virtually the IRP, RP has got no control. And to my understanding, this does not tantamount to the item covered in 28 and 28(3) provision that 66% majority of COC will require its approval is not the case. That is my position. And there are a couple of judgments also which have clarified this particular position. Whether IRP, RP is required to become signatory to the bank account, answer is absolutely no. And me and you will agree in many of the cases, we just require to have a control over the banking function. How I maintain that control? That could be one way that all payments which are approved under the authority of IRP. So once payment is approved, signing of check and other things could be delegated to the manager or to accountant or to the director or to the other people. If there is a managing director, he may continue to sign and execute the checks. But authority of IRP could be to approve those particular payments, or he could be a co-signatory as well. It is to facilitate the functioning, nothing else. As far as signing of the financial statement during CIRP is concerned, since the power of the board is suspended during the CIRP, the financial statement should be placed before the board and signed in the manner which is provided in section 134(1) of the Companies Act, and the IRP should also make a countersign. And in many of the cases where managing director, manager, director are not available, then IRP, RP will have no option but to sign and proceed for the purpose. Whether holding of annual general meeting is mandatory, since law has not given any exemption, more so the law and the circular, the January 2017 circular very categorically specifies that IRP, RP shall be responsible for doing all the compliances applicable. And time and again, the emphasis has been laid. So the IRP, RP has no option but to continue to hold the annual general meeting. And wherever it is required to seek extension, so he may seek the extension, but in most of the time, it is beyond the period of 3 months. So extension may also not work. But still, even if it is delayed, the annual general meeting for respective financial year should be held and the account should be filed also with the registrar of company to avoid any default. Whether financial statement needs to be adopted by the shareholder at AGM during CIRP, yes, there could be challenges because the promoter shareholder may continue to disrupt the proceedings and they may continue to defeat the resolution. If needed, you can take necessary support from the NCLT, and NCLT may pitch in and may provide necessary deviations, and your adoption may be approved by the shareholder. Whether process specified in section 139, 140 with regard to the resignation, removal of statutory auditor need to be followed. In absence of any deviation or modification in the Companies Act with regard to the appointment of a statutory auditor, with regard to resignation of a statutory auditor, with regard to removal of a statutory auditor. We have no option but to believe that you are required to follow the same process, what is prescribed therein, howsoever challenging it may be, howsoever cumbersome it may be. You can't assume that because you are IRP and during the period of CIRP, all powers are vested automatically with you. It is only the power of the board, and that's too, as we discussed earlier, in a limited manner will fall back to you. Rest all powers will remain with the respective shareholder and the regulator. Let us come to the part of interplay of IBC with the SEBI law and regulation.
Sir,
We
one
do
query can I raise? Sir, one query
Yeah,
can
yeah,
I raise? Sir,
please.
whether it is possible, suppose a CIRP has started on a particular date, and there are only two directors of the company, and both of them have already resigned from the company by submission of form DIR 11 and 12 with on the portal, and there is no office, nothing of the sort, and no directors, nobody, no employee, nothing is there. How to tackle it?
No, now the choice is, it is of course, as far as the compliance of law and to have a minimum number of 2 or 3 director as the case may be, that is one obligation. But you can't
But that is not there.
really find. Yeah, I'm coming to that. I'm saying
Okay.
it is not possible in many cases where you will be able to find out a person to be appointed on a company which is already under the CIRP. Why anybody
Yes.
would be willing to give a consent, right? So this is a situation which is fait accompli. Howsoever best effort you can make, but you may not be in a position to find out somebody who is interested in running the operations and putting his life into the danger unnecessarily. He may not give his name. So this is a fait accompli situation. Even if the matter comes for consideration, you can always bring the matter before the committee of creator, and you can inform to the concerned NCLT also in the progress report as well, this is the situation and we will not be able to comply with this particular provision. So if I am doing that beforehand, there should not be any problem with regard to the same.
No, sir, the point is that the clarification which I require is whether the directors are competent enough to resign, leaving the company in the limbo, that nobody is there to take care. Whether it is possible or it is mandatory for them to ensure that at least there are two directors at all points of time.
So I think, already given a clarification in the previous slide. I think you may have missed out, and that was the clarification which was here, right? This clarification says Madras High Court in P. Murari versus State. In the absence of any provisions relating to resignation in the Articles of Association, it is well settled that resignation once made takes effect immediately. When intention is to resign is made very clear. Where Article of Association of a corporate debtor require board approval for the acceptance of director's resignation, or resignation is subject to the board approval, IRP or RP may approve such resignation after getting approval by vote of 66% majority in the COC. In other cases, the resignation will be effective immediately. Moreover, in the matter of NCLT Chandigarh, in Ashwani Mehra versus Vinod Kumar, Dandona and others, and Oasis Agro Infra versus Mandeep Singla and others, it has specified that section 19 of IBC also requires ex-personnel of the corporate debtor to cooperate. So despite resignation, the RP may seek necessary assistance from such director. The point that I am trying to re-emphasize if articles of association of the company does not prescribe the resignation to be approved by the board of directors, the resignation will be automatic. The RP will not be in a position to withhold the same, and that will not require to be approval before the committee of creditor even. Only in those cases where article prescribes, there the matter will go for approval. And in any case, the Chandigarh judgment is very important, which says that nothing stops you from. Sir, can you please mute? Now, you can unmute and ask the question again.
Okay.
So, yeah. So, your apprehension that if I approve the resignation, then who will be there to support me? Both apprehensions are unfounded. A, you don't have any authority to consider that unless I approve, the resignation will not be valid. That is point number one. Unless your article says otherwise, you please check your article. Number two, the apprehension that he may not come forward to cooperate, even if he resigns, even if he is an ex-employee, even if he is an ex-director, his obligation under the insolvency and bankruptcy code still remains there. He will be required, and even I can go and file section 19 application before the NCLT to seek cooperation from him. But I can't withhold, and on the premise that unless I approve, his resignation will not be valid. I don't think that is the correct proposition. Even if I don't file, that I think if I don't file, then the filing delay will be on my part and I will be guilty of the sin. That is my view. If that clarifies.
Some clarity. It means there situation can come where there is, when you take charge as insolvency professional of the company under CIRP, there is no director, and when we ask for any information,
Possible.
fine, under 19, it is possible then. And so under the 19, we can ask for information, and his reply to each query comes that since I have resigned from this place, I don't have any information with me.
No, that really he cannot take an excuse, because the NCLT is seized of the matter that he can direct, NCLT can direct that you have no choice to run away from the show, and your deliberate action shows that you are guilty. You have been part of this, whatever fraud and other things might have taken place, and now you are running away from the show, and they may pass necessary order also. I agree. You may be in a difficult situation, but that situation may still be there even if he continues to be the director. He may say, I am not in a position to provide you any information. Simpliciter, which is happening in majority of the cases. And unfortunately, 19.2 has not came very handy, and it has not been proven to provide any solution even in those cases where the directions are there by the NCLT. NCLT is repeatedly giving the direction to provide the necessary support and information by passing the order under 19.2. But despite those orders, the orders are not getting implemented, though there is a power to contempt. But in majority of the cases, the situation is like that only. Either it is partially non-complied, or it is fully non-complied, or it is partially implemented or fully not implemented. But matter of fact, the point, that legal point that we are debating, can we withhold the resignation of a person? To me, answer is no, unless only one situation where your resignation is dependent on acceptance by the board of directors. So now board power is vested with IRP. So IRP may say, no, it is a very crucial time. I won't allow you to leave the organization if you have a basis. And that's to happen majorly in the cases of a full-time director or the executive director or the managing director, where there is a contract of employment. Where there is no contract of employment, non-executive director per se, you cannot push that he needs to work on my dictum only. Now, unless I approve, he cannot go. Now, I don't think that will work.
Sir, one thing more. In such cases, since there are no other directors and we are calling the COC meeting, should we invite those directors as by forwarding them the agenda and minutes that you come and join?
We can definitely, yeah, as we are doing it for the suspended management, although they are not no longer a suspended management because they are no longer a part of the management itself. But there is no harm because we have no other person. So in the interest of committee of creditors, because if they are present, at least their skin is in the game. Tomorrow they cannot say and allege to the committee of creditors that they have taken a wrong understanding and wrong premises in respect of some of the matter. So with the permission of committee of creator, I don't see that there is any difficulty. As far as where the confidential matters are being discussed, I think we can take their recusal from those matters, and other matters we can discuss before them also. That will safeguard and that will prevent us from doing something unwarranted tomorrow.
We are sending them the agenda and minutes, but they are replying to that only that since I am not the director, don't mark the application to me. 92 is already filed, that is pending since 2023. 15 dates have already gone in court 5, but nothing has come out still. Matter does not reach, and the next date comes after 2 months. It was filed sometime in December 2023.
Yeah,
it is still pending.
I know.
No hearing.
Yeah. I know, sir, fairly. This is the pain of all insolvency professionals nowadays because they have hardly very few tools available. 19 section is one tool, and that's too also is not coming up very favorably from the NCLT side, primarily because of the delay. Because one side we are saying that you have a very limited 180 days time for the purpose of completing the whole process. On the other hand, when we file the application for seeking some information, cooperation for want of information, my entire CIRP process is withheld. On the other hand, I am always running with the risk that I am crossing the timeline of 180 days, and when we go for extension, we are left in lurches that how much time you need more for the purpose of closing this process. So I can understand the pain, but I think yeah, we are left with no option but to. I think we have to bear this collectively, and we have to keep representing before the IBBI that this is a need of ours, that we need to have some workable solution. Just filing of application is not enough. There has to be a mechanism by which we should be provided the surety that the necessary information what is being asked for, at least that minimal information should flow to the IRP RP so that he can proceed with the and take necessary decision in respect of. That is the point.
Fine, sir. Sir, will you please share this PPT or presentation which you are showing? That can be quite handy.
Yeah. We will be sharing this presentation to the institute, and institute will share to all the participants who have joined. There is no difficulty. Otherwise, I will share personally.
Thank you for clarifying.
On the point of an interplay between SEBI and IBC, we will run through the framework. Then we will come on item by item relaxations under SEBI LODR, ICDR, SASC, delisting, securities contract regulation, securities contract regulation rule, and the issues which require the attention. And also we will see the interplay between the IBC and SARFAESI. What is the framework? If you see, the framework is like Insolvency and Bankruptcy Board of India Circular, 3rd January 2018. Section 17(2). Both mandate that insolvency professional has to ensure that the company complies with applicable law, including SEBI LODR. LODR 3rd Amendment 2018 effective from 31st of May 2018. Point 16 was inserted in para A of part A of schedule 3, which is dealing with material information disclosure to the stock exchange. The information which was requiring the disclosure with regard to commencement of CIRP, commencement of filing of application by operational creditor, by financial creditor, by the corporate debtor itself. Third amendment only provided effective from January 2021, some disclosure requirements were modified. Then came the guidance note, which was effective from 9th of July 2021, which mandated certain further disclosures. Guidance note, which was issued by SEBI.
Sir, please include all this in the presentation, number
Provided-
and reference. Otherwise, we will not get it.
Number and reference.
Number and reference of the circular and date which you are referring to, SEBI circular amendment, LODR amendment. Please include it in the PPT presentation. Otherwise, we will not get it. And it is so fast that we are not able to record it also.
It is already there. It is there in the this particular document itself. If you will go on the particular, and if you still require any particular document with regard to the reference circular, you can reach out to me, or you can email it out. You will get. Otherwise, majorly whatever was considered necessary, we have included that thing. But point noted, I will try to include that whatever is possible.
Yes, please, sir.
Now, disclosure under Regulation 30 regarding commencement of CIRP with the stock exchanges. As disclosure is required to be made through the listing center, IRP is required to make a request to the compliance officer. Say you are appointed as a IRP of a listed entity. How you will proceed? Maybe there is a company secretary in the listed entity. Most situation it will be, or maybe it is not. In either of the situation, you may not get a cooperation from the company secretary or a secretarial team with regard to making of the disclosure. There will always be a disconnect. You will say that you need to file this information, and they may not file. And particularly in a given frame of time, what you need to do, you need to escalate the matter to the listing department of the concerned stock exchange, request them for creating a temporary login and password. They will share you. Now you will have access to that temporary login. Through that, you will be able to file all the information and records with the stock exchange. That is point number 1. Now, exchange shall identify and tag the security in a manner which will be easy for members and the market participants to know that the security is currently under the IBC proceeding. This is the obligation on the part of the stock exchange, that they have to identify which companies have came into CIR. So especially the message will come when the search will be made on the screen with regard to that company by putting a symbol that this company is presently in CIRP with effect from so and so date. And what is the stage and other things will also be reflected. So anyone who is dealing, because during CIRP also the trading continues. So the investor should not be in dark. That is the purpose. Rule number 3, the exchange will continue to provide an alert at the time of order entry, informing the market participant that the scrip is undergoing CIRP And members shall also be advised to incorporate this alert promptly in their front-end system. What does that mean? Exchange will not only put an alert on the general website, but as and when the order is punched by the market participant for purchase of that any script, the message will flash that this company is in CIRP. Do you really want to purchase this share? This kind of message is to give an alert. This alert will be available from the day of admission into CIRP till the day of suspension of the company or exit from the CIRP proceeding pursuant to NCLT order. In instances where resolution plan provides the value of listed security is considered zero and company has to be delisted, or where the entire equity capital is reduced, cancelled, extinguished without any payment of existing equity shareholder, exchange in coordination with each other based on intimation of the oral order from the company or RP, confirming the aforesaid position with regard to resolution plan, shall suspend the trading in the company on immediate basis. This is a landmark measure because prior to that, what was happening? Today, say there is a hearing going on in respect of one of the listed entity resolution plan. And resolution plan provides that the listed security value will be zero or the securities are proposed to be delisted. Now order comes 15 days after. Exchange is intimated on the 16th day. From the date today to next 16 days, the trading is happening on. The people who are aware that this entity is going to be delisted, they are selling their stock. People who are not aware, considering that there is a discounted price at which the shares are available, they purchase, causing a loss to the investors. So SEBI came out with a mandate that the moment you come to know, even in an oral order, in an oral pronouncement, where it is said that company will be delisted or the value of shares will be zero, exchange has to compulsorily take into cognizance and suspend the trading of that particular script on the immediate basis. Exchange will monitor on a regular basis the compliance of all companies under the CIRP from a disclosure perspective, and any non-compliance observed will be reported to SEBI for further action. So whatever is reported is compiled on a time frame basis and is intimated to the SEBI if there are any deviations. Under SEBI LODR, there are quite obligations with regard to compliances. There are certain exemptions also, like shareholding pattern is required to be submitted. Now timelines have recently undergone a change. Everything majorly is now under the two basket. It is within 30 days of time in general. Corporate governance report, financial result continues to be declared within 45 days or 60 days for the last quarter. Reconciliation of share capital audit report, earlier also it was 30 days, now also it is 30 days. Statement of grievance redressal mechanism, now it is part of the integrated governance report. Statement of deviation, variation, now it is part of integrated financial report. Disclosure of related party transaction, now it is part of integrated financial report. Then there are certain other obligations with regard to payment of fees, filing of the secretarial compliance report, then the annual report, share transfer agent, disclosure of related party transaction, transfer transmission, intimation of appointment of share transfer agent, in principle approval for issuance of security, bonus, dividend, and prior intimation of board meeting for consideration of the financial result. In case of a alteration in the name of the security, the prior intimation and regulation 36 disclosure and regulation 4010, where the transfer of shares and transposition happens, the report is required to be submitted. Now this is scrapped. So these are the major disclosures which are required to be made. In addition, the material events, whatever take place in regulation 30, there are certain disclosures which are required to be made from time to time basis what is the materiality. And the materiality in respect of part A item is not required to be determined. They will always be considered to be material. And as and when those items happen, those items will be required to be disclosed. Now, let us understand what is the relaxation. During CIRP period, regulation 15, which is chapter 4, deals with the corporate governance. 17 deals with board of director, 18, 19, 20 deals with the committee. Now, audit committee, nomination remuneration committee, stakeholder relationship committee, and so on. 15(2)(a) has been added, where it provides that the provisions as specified in regulation 17 shall not be applicable during the CIRP period, provided that the role responsibility of the board of director as specified in section 17 shall be fulfilled by the IRP-RP. Two components. One, regulation 17 is not applicable during the CIRP period, and the duty will be fulfilled by the IRP-RP. 15(2)(b) says the provisions with regard to committee, that is audit committee, nomination remuneration committee, stakeholder relationship committee, will not be applicable because there will not be a requirement to have an independent director as such. And provided that the role responsibility of these committees shall also be discharged by the IRP-RP. Similarly, regulation 23 dealing with the related party transaction, 23(4) says all material related party transactions shall require the approval of shareholders through resolution, and no related party shall vote to approve the related party transaction, whether the entity is a related party to the prescribed transaction or not. And it also says, provided that the requirement specified under sub-regulation shall not apply in respect of a resolution plan approved under section 31. So if some related party transaction is envisaged in the resolution plan which is considered necessary, to that extent the related party transaction restriction in regulation 23(4) with regard to the shareholder approval will be exempted. Mind you, it is only relaxation during the approval of a resolution plan. During CIRP, there is no exemption, there is no waiver with regard to related party transaction. We need to be careful. Material subsidiary. In respect of regulation 24(5), if a listed entity is having some material subsidiary means the net worth of material subsidiary is more than 10% of the total net worth of a consolidated holding company or turnover. And if you decide that you want to dispose the material subsidiary by more than 50%, then you cannot do unless you pass the special resolution. Now, listed entity can dispose of its shares in the material subsidiary by more than 50% with passing of a special resolution in general meetings, except a scheme or arrangement approved by the court or tribunal or under the resolution plan approved by the section 31. And such event is disclosed to the recognized stock exchange within 1 day of resolution plan being approved. What does that mean? General rule is that if you want to dispose of more than 50% share in the material subsidiary, you cannot do so except you take the approval of shareholder. However, if it is done as a part of an approval of a resolution plan, you will be not required to go for approval of a shareholder, provided you disclose this information within 1 day on the stock exchange platform. Similarly, listed entity is restricted from sale, lease, disposal of more than 20% of assets of its material subsidiary, except without passing of special resolution. So if I want to sell the assets of a material subsidiary, I require the shareholder approval. But if you are doing it as a part of a resolution plan, you can do so, provided you make a disclosure to the stock exchange within 1 day. 31A deals with the reclassification. So I am, say, promoter and promoter group today. Tomorrow, I want to reclassify myself to non-promoter group. As a part of a resolution plan, I need not follow the process which is prescribed in regulation 31A if it is a part of the scheme of a resolution plan. Whatever is approved, there were 3 promoters who are now going out and new 3 people are coming. Fine, all those people can become a promoter without getting into the nitty-gritties of a regulation 31A. 37 is with regard to the approval of stock exchange with regard to the undertaking of any scheme of amalgamation, demerger. However, if you are doing it by way of a resolution plan under regulation 31, you need not take the approval of stock exchange for the purpose of implementation of that scheme. You can straightforward go because time is the essence. If you come to Schedule 3, Schedule 3 now mandates that filing of application by corporate applicant for initiation of CIRP with the specification of the amount of default. When application is filed by the financial creditor, when admission of application is done or rejection is done or withdrawal is done, whenever there is a public announcement, whenever list of creditor is published, whenever there is an appointment replacement of a resolution professional, or whenever there is a prior or post facto intimation of committee of creditors meeting, whenever there is an invitation for resolution plan, number of resolution plans received, whenever the filing of resolution plan is done with tribunal, whenever approval of resolution plan or rejection of resolution plan is done by the tribunal. What are the proposed steps which are taken by the incoming investor, acquirer for achieving the minimum public shareholding, and the quarterly disclosure of the status of achieving the minimum public shareholding, and the details as to the delisting plan. If there is approval by the resolution plan, that will also be intimated. Now, this was quite a debate that whether this information should go in the public domain or not. But SEBI finally came out with the clarification that pre and post net worth of a company, that is pre-resolution plan and post-resolution plan, will be intimated. Details of assets of the corporate debtor post CIRP. Details of securities continuing to be imposed on the company's assets. Other material liabilities imposed on the company. Detailed pre and post shareholding pattern assuming 100% conversion of a convertible security. Details of funds infused in the company. Creditors paid off. Additional liability on incoming investors due to transaction. Source of funding. Impact of investor revised PE. Return on net worth ratio. The promoter's resolution applicant past experience in the business. In case where promoters are companies, history of such company and name. Brief description of the business strategy. There is a requirement to make a prior intimation of at least 2 working days intimating about the date of hearing where the NCLT would be considering the resolution plan. You also are required to make disclosure of approval of resolution plan to be made to the stock exchange on oral pronouncement or otherwise of the order on immediate basis, not later than 30 minutes. The resolution professional shall inform through the exchange platform any impact on the existing holders, investors of listed securities on areas such as status of listing, the value of holding of equity holder, right of cancellation, extinguishment of existing equity shares, preference shares, debentures, without any payment to the holder wherever it is applicable. Companies' resolution professionals are advised to be guided by the provisions of LODR and advised to maintain the confidentiality of the resolution plan until the details are submitted to the exchange platform. So whatever is mandated in this particular circular of 2021, that much information in this particular format will be required to be submitted. Rest all information is supposed to be maintained confidentiality, and the resolution professional will also be bound to maintain that confidentiality, and SEBI PIT regulations will apply mutatis mutandi on the resolution professional also. Next comes the relaxations for companies under IBC under the SEBI ICDR regulation. Considering that there is quite a possibility that resolution plan may envisage issuance of fresh security on a preferential allotment basis. And if a corporate debtor is asked to comply with the provisions of SEBI ICDR, then it becomes quite cumbersome, and which was the case which was being faced when the listed entities were in CIRP, and resolution plan, what was being contemplated, was getting this kind of challenge and difficulty. So SEBI came out with general exemption in respect of all entities. The chapter 5 deals with the preferential issue of security. Now 158(2) was modified to say that the provisions of this chapter, except the lock-in, shall apply where the preferential issue of specified security is made in terms of scheme approved by BFR under SICA or resolution plan approved under section 31 of the Insolvency and Bankruptcy Code. So if resolution plan envisage the preferential allotment of security to some resolution applicant or investor, then it is exempted. But mind you, it is only and only when you have a approval under resolution plan, otherwise no. Just give me a second. Hanji sir. Sorry. So this was a relaxation. Then similarly, when we go to regulation 170 with regard to the allotment, it also says that provided further that requirement of allotment within period of 15 days shall not apply to allotment of specified security on a preferential basis, provided it is approved under the resolution plan under section 31. So that 15 days condition, only lock-in requirement will continue to be there. There is no relaxation from the lock-in of security. (167)(4). The equity shares issued on a preferential basis pursuant to resolution of a stressed asset under the framework specified by the Reserve Bank of India or resolution plan approved by the NCLT under the IBC shall be locked in for a period of 1 year from the date of a trading up. This provision continues. And 167(4) says, provided that the lock-in provision shall not be applicable to specified security to the extent to achieve 10% पब्लिक शेयर होल्डिंग, मिनिमम पब्लिक शेयर होल्डिंग के पर्पस के लिए जो लॉक इन का रिक्वायरमेंट था, दैट रिक्वायरमेंट विल बी एग्जेम्प्टेड. 161 with regard to the preferential issue, it says in case of a preferential issue of equity share, the date 30 days prior to the date on which the meeting of shareholder is held to be considered for the purpose of preferential allotment. However, in the case of a resolution plan, the date of approval of the corporate resolution plan shall be considered as a relevant date. There is no requirement that you have to go back to 30 days and find out the relevant date, price, and the valuation. Chapter 6, dealing with the consideration and chapter 5, part 6, dealing with the consideration and allotment, This says that full consideration of a specified security other than warrant shall be paid to the allottee at the time of allotment of such specified security, except in case where it is issued for consideration other than cash. Now, 169(1) as amended has included a proviso which says that if a preferential allotment is done as part of a approval of a resolution plan, the consideration shall be as per the resolution plan approved by the whatever is mentioned. Say it says the payment will be made in 2 tranches, so it will be in 2 tranches. If it says it will be upfront, it will be upfront, or if it is a multiple tranches, then it will be a multiple tranches. Similarly, there are some relaxations under the SEBI SAST. So whatever ecosystem was supposed to be amended for the purpose of implementation of a resolution plan, that has been provided by the SEBI. So is the SEBI SAST also. Now, Regulation 3.2 mandates that anyone who is acquiring any shares either alone or along with person acting in concert, if he is crossing the threshold of 25%, he cannot do so unless he comes out with the open offer. So I am a person who along with the other person or alone wants to acquire more than 25% in any listed entity. I cannot do unless I make a open offer to other shareholders. But for a company which is in CIRP, Regulation 3.2 has been amended to provide a proviso. It says that if an acquisition is pursuant to resolution plan, the provisions of Regulation 3.2 shall be exempted from the obligation of giving an open offer. So maybe I am acquiring 75% of equity of the listed entity from its promoter. No open offer is required. Because if I ask for the open offer, it is a 3 to 4 month process. The 180 days timeline will go away. What will be the impact of resolution plan? It might not be implemented because of the variation in the price and other things, and it might defeat. So resolution plan is approved, but acquisition still does not happen. That way it is relevant that we continue to have the exemption. Similarly, Regulation 10(1)(da) of SEBI SAST regulation, what it mandates, Regulation 3 puts restriction on acquisition beyond 25%, 4 puts restriction on acquisition of control, and 10 provides general exemption. And in 10(1)(da), it says any acquisition which is done pursuant to resolution plan will also be exempted from the compliances of Regulation 3, that is open offer condition will not be applicable. Similarly, delisting is a very common thing. Almost 70-80% companies which are listed post resolution are getting delisted. So delisting regulation amendment primarily says that Regulation 3.2, which deals with the delisting, will not apply if a delisting is made pursuant to resolution plan, provided that the existing public shareholder shall be provided the exit opportunity at a price which shall not be less than the price by whatever name called at which the promoter or promoter entity are being provided. So if I am giving 10 rupee per share to the promoter, I will have no option but to provide 10 rupee to the general public also in the exit offer. Also, it says that the details of delisting of such shares along with the justification for the exit price in respect of the proposed delisting shall be disclosed to the recognized stock exchange where shares are listed within 1 day of the approval of the resolution plan. Then there is one more regulation 42A. Now, what is 40 regulation? It says any listed entity which has undergone a voluntary delisting cannot come for listing again within a period of 3 years. And the one which is compulsorily delisted cannot come up again within next 10 years. However, if you are delisted pursuant to resolution plan, then this provision of regulation 40 will not be applicable. That means you can come back again and list your security. Similarly, Securities Contract Regulation Act and Securities Contract Regulation Rule 1957. Very important part with regard to the minimum public shareholding. As you know, for a general listed company, the minimum public shareholding is 25%. Now, in case of a resolution plan, it is quite possible that this 25% reduces to maybe 15%, maybe to 10%, maybe to 5%. Regulation 19A5 Mahesh, you have some query? So regulation 19A5, which deals with this situation where public shareholding in a listed company fall below 25% by virtue of implementation of a resolution plan, it will bring it back to 25% within maximum period of 3 years. So you get a 3-year window to restore it back to 25%. That is rule number 1. Rule number 2 says if it is falling below 10%.
One small doubt, sir. 3 years from the date of such fall means which date, sir? Fall is okay, but suppose if it is before the resolution plan approval, is it that period has to be reckoned from that date?
No. Madam, the condition is that your minimum public shareholding should fall below 25% pursuant to resolution plan. Now, it can not happen any situation prior to implementation of a resolution plan. During
plan approval or implementation, sir?
Plan approval. Please listen. It will depend how your resolution plan is worded. If your resolution plan says on the date of approval of resolution plan, the shareholding of the existing promoter will get transferred to the new promoter, or the reduction of capital will take place without any further action. So you need to see what is the language. If there is any corporate action which is required to be done after approval of the resolution plan, from that date. Otherwise, it will be from the date of a resolution plan.
That's fall. Okay. And now, one more doubt, sir. Sorry if am I interrupting you?
No, not at all.
Sir, there are some companies which are not listed, but they have not filed their DAR 12 after implementation. There is a delay. What should be the date, sir? Actual date?
No, if they have not filed their DIR 12, you can file that DIR 12 today also. There is no difficulty with regard to filing of that DIR 12 with regard to changes in the director. And ideally, it should be filed, because if a company goes for resolution, in any case, they will be required to do all pending compliances as well.
What should be the date of appointment, sir? Because it carries fees, no? So
fees and all part in respect of matters which are considered of that nature. The fees relaxation is in respect of only the annual filing forms. In respect of other forms, the exemption from the fees is not available, right?
Yeah.
So you have no option but to pay the additional fees. That fees exemption will not be available. You can't change the date.
Okay.
Yeah.
Okay.
Yeah.
Thank you, sir.
Maheshi, you have some query? You have unmuted couple of times, but your voice is not coming.
Sir, excuse me.
Yeah.
Sir, that what is the rate to be quoted for the shareholders in case of the in such a cases? So what will be there? Any listed and unlisted? Is there any difference? Is there actually?
Rate of what? Shares.
Rate at what rate to be given to the shareholders actually?
No. It is public. You will be purchasing, say the entity is going for delisting. It will be at a price not less than the price which is offered to the promoter. So if you are paying, Shekharji, you please kindly mute.
Hello.
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 Hello. हाँ जी बोलिए.
Sir, there is a disturbance. Hello. Sir. Hello.
Yeah, Shekharji, I am answering. Please wait. So what I am saying, the rate of security at which the promoters or the resolution applicant will be purchasing those securities will be as per the resolution plan.
Okay.
Depending on what terms and conditions have been finalized by the resolution applicant, basis that the offer will be given to the general public also for tendering their shares if the securities are proposed to be delisted or otherwise. In all situations, the price discovery will be as per the resolution plan. Whatever resolution plan says, basis that it will go. However, in no situation, it can be priced less than what is being paid to the promoter. The promoter is being paid at rupees 10. You will have compulsorily to pay at rupees 10 to the general public also.
But the promoter, it should not be less than 10 rupees, but we can give it as more than 10 rupees also. Suppose the fixed is 10 rupees. That way,
But why point is that, Shekharji, why any promoter, why resolution applicant would like to pay more than 10 rupees, right? If he is doing so, then he may be doing so on the wish that he may acquire maximum, say he is able to acquire 90% or 95%. But he wants the remaining 5% also to be purchased. If he want to shell out extra money, government or regulation does not stop you. So if you want to pay to attract at the rate of 12 rupees per share, so that you can get remaining 5% from the public, all right, you can do so.
okay.
Only minimum price is restricted. Maximum price is, in any case you are not doing any injustice to the public at large. You are paying even more money.
Okay, sir. Okay. Thank you.
So one situation, if I am falling below 25%, 3-year window to restore it back to 25%. If I am falling below 10%, then I have a 12-month period to restore it back for the purpose of this minimum public shareholding. And if a listed entity has to maintain minimum 5% to remain listed, if I am falling below 5%, then I have to go compulsorily for a delisting. These are the three general principles and general rule with regard to the minimum public shareholding which we need to adhere. Meeting of board, I think we have discussed. It is the petition. It is the same principle. Let me see what is corporate actions. Also, we have covered compliances. Also, we have covered. There are some issues which I have mentioned for attention of IBBI for consideration, and since ICSI IIP is also there, they may also take note of these concerns of the resolution professional. In many cases, we have seen the mandate is that there is a requirement to make a prior intimation of at least 2 days, 2 working day prior, where the NCLT hearing is scheduled. In many cases, we come to know from the cause list whether the matter is coming up for listing or not, whether the matter will be heard or not. So at times, it becomes very challenging that we are not able to give prior intimation of 2 days. It is only 1 day, or in many cases, only 12-hour window is available for the purpose. So government may consider relaxing this particular provision. Disclosure of approval of resolution plan to the exchange on the oral pronouncement within 30 minutes. Now, oral pronouncement intimation in many of the situation may be little difficult because you may be attending the hearing virtually. You may not have heard properly whether the entity is getting delisted or not delisted, whether the shares value is considered to be 0 or not. So there may be possibility of a miscommunication. That is point number 1. Or there may be possibility that the RP is not able to get into that particular hearing. So tomorrow it will be the embarrassing situation that we are not able to communicate to the stock exchanges with regard to that information. So these are the exception situation, I understand, and maybe some suitable carve out may be there tomorrow. It should not happen that IRP, RP is in default. Thirdly, what is the expectation of SEBI from the directors, independent director, committees, especially when Companies Act does not provide any relaxation with regard to the continuance of meeting and these committees. 23(4) provides relaxation only from the related party transaction which is envisaged pursuant to the implementation of a resolution plan, not otherwise. But what about the other cases? Suspension of trading. Present scenario is that I will continue to do the trading until resolution plan is approved and resolution plan says the value is 0, or the resolution plan says the entity is to be delisted. Now, lot of water flows. There are a lot of stakeholders, a lot of people involved who are privy to all that information. So, SEBI PIT regulation, where there is no exemption, plays a very vital role. How to ensure that fit compliances are ensured and no one is privy to or is misusing the price sensitive information to its own advantage. I know that resolution plan considers that delisting is proposed and delisting is going to be approved. With price sensitive information, I liquidated my stock. I informed to 10 of my known people also who liquidated the stock. Is it not insider trading? The requirement of compliance regarding approval of shareholder, creditor, regulator of resolution applicant in which the corporate debtor is merged as a resolution plan. So I am talking about a transferee company. So say transferor company is a company in CIRP. Transferee company is a healthy company. Law gives me the exemption in respect of transferor company which is in CIRP. What about transferee company? The section 230, 232 mandates the approval of code-driven process where creditor meeting, where everything is dispensed with. What if tomorrow some of the stakeholders come forward because they have not got any opportunity of being heard? So we need to, because we have crossed 8 years time and still we are not having a clarity with regard to this particular aspect, may be clarified. Now, can we also think of creating a platform on the lines of dissemination board to get listed entities in liquidation? Because what is happening, the moment the announcement is made with regard to the suspension, the details of the entity vanishes from the stock exchange portal. Now, if I want to get any information for the prior period also, I am not able to get because the script has moved out from there. So can we create a dissemination board kind of platform? Then regarding the levy of penalty on defaults prior to CIRP period and during CIRP period. What is the final take? Can that be recovered by the corporate from the corporate debtor, or the stock exchange will have no option but to file it as a claim, and as per section 53 mechanism only or as per resolution plan only they can get the money whatever is due. We come to the last part and then we'll open the question answer. If I talk about the interplay of insolvency bankruptcy code versus SARFAESI, while both law addresses the debt recovery, their interplay arises in scenario of borrower's default, where secured creditor may initiate SARFAESI proceeding, but insolvency and bankruptcy initiation can halt or it can override them to prioritize the holistic resolution. If you talk about the SARFAESI, is a creditor-centric law designed to enable bank and financial institution to recover dues from defaulting borrower by enforcement of their security interest, maybe seizing, auctioning, collateral asset without lengthy court intervention. It targets the NPA and operates through the mechanism like notices under section 13.2, 13.4 and involvement of debt recovery tribunal. In contrast, IBC provide a comprehensive time-bound framework for resolution of CD, focusing on rehabilitation, restructuring, liquidation to maximize the value of all stakeholders. It introduces the concept of CIRP, moratorium, committee of creditor to oversee the resolution plan. This is a broad overview between the two if you talk about, and if we want to compare item by item also, to focus, approach, scope, key mechanism and judicial role. To focus in SARFAESI is quick recovery of secured dues. In insolvency, it is insolvency resolution, rehabilitation, or liquidation. SARFAESI is creditor-driven, non-judicial process, whereas IBC is debtor in position with creditor oversight. Time-bound. In SARFAESI, the scope is individual, small corporate borrower, secured assets only. Whereas in insolvency and bankruptcy, it is no restriction, secured, unsecured, all type of creditors and corporate persons are covered. Key mechanism, you give the notice under 13(2), possession, symbolic possession, auction. In insolvency, filing of application under section 7, 9, 10, moratorium, resolution plan, liquidation. Here DRT oversees the process whenever required. Insolvency is by adjudicating authority, that is NCLT, or appeal goes to NCLAT and further appeal goes to Supreme Court. If you see the interplay between two, moratorium impact upon admission of a CIRP petition, there is a section 14 which comes into play, which puts the moratorium. And it includes the moratorium against the enforcement of security interest under SARFAESI, which bars the possession, sale, transfer of secured assets during the moratorium period. Protection of debtors' assets for collective resolution is the priority. However, if the SARFAESI proceedings have reached to the sale stage before moratorium, they may continue in a limited cases where sale has already been precipitated. As far as the pre-CIRP SARFAESI proceedings are concerned, the cases where secured creditor have pursued SARFAESI independently before IBC, but pending DIRT proceeding, do not bar section 7 application. So pending SARFAESI disposal, IBC can be invoked. As far as personal guarantor is concerned, for personal guarantor under IBC, interim moratorium halt SARFAESI action against the mortgage property, but proceedings can resume post moratorium. This is the interplay. These are few of the rulings. If I go to the apex court and the appellate court, they have consistently affirmed IBC supremacy to balance creditors' right with the systemic stability. And these rulings underscore that SARFAESI offers swift recovery in the simple cases. The IBC framework takes precedence in the complex insolvencies to prevent cherry picking of assets by the secured creditor, which is possible in the case of a SARFAESI. These are some of the judgment. There are n number of judgment on SARFAESI versus IBC. All judgments are primarily upholding the supremacy of the Insolvency and Bankruptcy Code. Innovative matter section 14 stated that Supreme Court stated that section 14 moratorium overrides SARFAESI, barring all creditor action to facilitate the resolution. In Indian Overseas Bank, RCM infrastructure clarified that SARFAESI sales completed pre-moratorium are valid, but post-admission actions are stayed. PNB versus Mohit Indrayan reinforced the IBC's moratorium prevailing position. And CLAT in the matter of Abhijit Ferrotech, the appellate tribunal set aside the NCLT order dismissing the Section 7 petition due to pending SARFAESI DRT proceeding, emphasizing the Section 238 override and the distinct nature of insolvency versus the recovery suit. because NCLT dismissed the Section 7 petition in this particular case. The personal guarantor matter with regard to the India Bull Asset Reconstruction Company versus Pawan Kapoor, NCLAT held that bank cannot invoke SARFAESI during the interim moratorium, even under Section 96 of the Insolvency and Bankruptcy Code. I think by and large we have covered most of the part with regard to interplay between insolvency and bankruptcy versus SEBI law versus Companies Act also we have touched, because to deal with SEBI law, it was considered necessary, and we have also seen a broad framework from the overview perspective with regard to the SARFAESI law. I'll be happy to take the questions from audience. Now you can unmute and we can discuss on whatever lines we have made discussion so far. Yeah, now you can unmute and we can discuss.
Sir, I'm Praveen Navandar.
Yeah.
What happens to the company bought under liquidation as a going concern? The change of status becomes very difficult. It takes almost 8 to 9 months or more than a year, and it doesn't happen because closure order is not passed by the NCLT till all litigation are clear, and the buyer is not able to run the company.
So you are saying, if I am understanding correctly, there is a ABC Limited which has got some assets, and those assets as a bucket have been acquired as a going concern, but entity remains over there.
Yes.
And entity has got certain litigations, right? And until
Entity NCLT litigation continues, say PUFE application continues,
PUFE
or
application,
or the distribution application continues. There are 4 bankers. There is a fight between the 4 bankers regarding distribution. So the RA or the person who is buying in the liquidation doesn't have any role in that. But the closure order is not passed, and the MCA is not ready to change the status from under liquidation to
So this
normal.
matter has been discussed time and again with the IBBI as well as Ministry of Corporate Affairs to raise the flag that these are the concerns of a resolution professional as well as the resolution applicant who is acquiring this kind of structure. So this is one particular kind of situation where there is a problem, but there are other areas also where the IBBI is exploring the other alternative available. Like in case of a liquidation also, the study says of the last 8 years, in majority of the cases, delay is primarily because of the ongoing litigation, which are not coming to end, and primarily which have germinated during the CIRP period or during the liquidation period. So I'm sure they will come out with some suitable mechanism, but as of now, that is a matter of fact and reality. Whatever you are saying is a matter of concern, but we also don't have any solution. We can express the pain jointly with the regulator that yes, we should work out on some mechanism so that it can come to the logical conclusion at the earliest possible time, rather than waiting for endless period. When the all asset, well, all the list has gone from there. There is remaining nothing in that particular entity to litigate upon. Then what for we are waiting for the litigation to come to end to make the status as dissolved. I understand the pain, but matter of fact is we don't have any solution.
It becomes a non-starter. Somebody investing say X amount and then repairing and renovation carried on. Now when the unit is to start, the status is not changed. Without status, the bank doesn't give new loan. The current account is not operational. All this difficulty, directors cannot be appointed. Lot of other difficulties are there. Because
no, you are talking about, then there is a difference. You are talking about a scenario where I have acquired a entity, corporate debtor entity itself as a going concern.
Yes.
If that is the case, then there is no problem, na?
No, then also the status change is not done very fast. It takes
status change means
The MCA
status
status of the company is under
now that is
liquidation.
happening. Now that is happening. Earlier there was, that is what I was telling. INC 28 form was previously not mapped. Even if your case currently, if you are not able to, if you have filed already the INC 28 with regard to the order of NCLT and status has not updated, it was previous era, I will request you to file a fresh INC 28 attaching a previous INC 28 so you don't bother to go for condonation of delay. And then basis that the status of a company will move from under liquidation to active, and then you can do whatever appointment of director and other things are done. We have tried this and we are able to do that.
This is done with effective when? Last 2 months only or when it was done?
I can say about maybe since the last July, I think 14th of July onward.
Okay. One more thing for listed company, the relisting of shares becomes very difficult because wherever the relaxation is granted for resolution plan under section 31. And when a person buys the company under liquidation as a going concern, it is not considered as a section 31 application. And so the order is there, but SEBI and stock exchange are not taking it up for relisting of the said companies.
That is correct. If the status has gone, the company has gone into liquidation, right, which is already marked and which has already been informed, right, you have no option but to follow the fresh process. This is also a pain point which is under consideration of SEBI. IBBI has already flagged this issue. SEBI has got certain view and they are insisting that if IBBI is able to carve out as its exception that it will also be considered equivalent to a resolution plan, then we don't have any observation, right? Otherwise, they are talking in between and maybe some solution will be worked out. But as of now, there is nothing on card.
Actually, the
That is
resolution applicant suffers. No, means the person who has bought the company under liquidation suffers a lot because of that.
but that is true. But Praveenji, point is that this is not something which is not known prior. Now, Praveenji, this is known prior to acquisition that this entity will be delisted or the status is delisted as on date, right? I will not be able to claim it as a listed status. It is not that somebody is hoodwinking you or making a misguiding. So taking that I am not getting afterward listed status is also not correct. It is not as a matter of right, but I agree principally. The same benefit what flows from the resolution plan approval to the entities in CIRP with regard to the listed status should be available to these entities also, which are sold as a going concern during the liquidation as well, right? There is a possibility that SEBI can come out, but they are also not able to figure out as to what should be the right way to come up with the solution. But some solution may be coming. As of now, there is nothing. Your point
And
is valid.
section 79 of income tax is applicable only for a resolution plan, but which is not applicable for a company which is taken over under the liquidation. Though it is akin to resolution plan, the carry forward of losses is denied in this matter.
Now, because of you are saying because of the change in management.
Section
Because
79, a relaxation is granted under resolution plan takeover and loss is allowed to be carried forward. But for other cases, company bought under liquidation as a going concern, which is just akin to resolution plan, but the benefit of carry forward loss is denied.
79 benefits should be available, but I'm not very sure. If you are saying, I will just recheck and you can text me your contact number. I will get in touch with you, or you may call me maybe on Monday.
Okay,
I will
I will take
inform
your
you.
number from Anjali madam.
Yeah, okay.
And one more thing, 79, this, that. And nowadays, NCLT benches have started refusing to accept the waiver application. That is also a very big challenge. If I buy a company, I need all waivers, which earlier we used to apply for a waiver application. Now I am told that few benches have started refusing to accept the waiver application.
The waiver was never a concept under the insolvency and bankruptcy resolution. Section 31 nowhere in the envisaged. It says
No,
if
it's
you
not section 31, but liquidation as a going concern when I buy. Whatever I pay, it should be the end of it, and I continue the company. The company's all liability should be discharged. No. Now, if I'm buying a company
no,
under
but
liquidation,
that way they are considering whatever consideration you pay, that is the due discharge of all existing liability. You will be coming on a clean slate basis only. Section
yeah,
32A, Section
that is
32A will be available to you as well.
correct. But under liquidation earlier, a waiver application was filed,
But
and
can you
now they
explain
are.
what kind
See,
of
if you,
waiver you are?
I will discuss one to one. Lot of
Okay.
waiver applications were given. If you see, few orders are there. Quality foods order is there, and lot of other orders are there, where all the benefits of resolution plan were passed on to the person who is taking the company under liquidation. But nowadays, in few NCLT benches, they have started refuse to accept the waiver application.
We can discuss certainly.
Yes, sir.
I can check with you.
Yes, sir. Thank you.
All right, my pleasure. Anyone else to discuss anything or share any experience with regard to any of the matters relating interplay between SEBI and IBC? So, Anjali, if you are there, if there is anything, then we can take up or we can close for the session today. Anyone from ICSI? Yeah, all right. I think there is no one from ICSI. Since our discussion, if anyone has got any question, then we can take up or we can close the session for today. Thank you so much for your time and interaction that we had on this very important subject. Thank you so much.